this dilemma.
Well, Melanie, if I could just start by addressing a point that the court had posed just before we broke for lunch, which was, well, what is the position where you have a claim form which obviously makes no reference to a remedy, to an injunction, but then you've got particulars of claim either provided with or subsequently, which does make reference to an injunction for which an additional fee would be paid. Well, it certainly seems to me, my lady, if one looks at the fees order, this is page 23 of the authorities bundle, and it's just under the passage that we looked at earlier when it talks about having to pay both the payment for a claim for money and a non-money claim as well. So that was 3 rows down, where a claim for money is additional to a non-money claim other than the claim for recovery of land or goods, then fee 1.1 is payable in addition to fee 1.5. Then if you go 1, 2, 3, 4 rows down, we then have slightly difficult in terms of the way it's been set out. And it says fees 1.1 and 1.5 amendment of claim or counterclaim. And it says where the claim or counterclaim is amended and the fee paid before amendment is less than that which would have been payable if the document as amended had been so drawn in the first instance, the past amended document must pay the difference. So in my submission, that takes account of that scenario, which, so applying that to the current case, claim form makes no reference to the remedies referred to, either the injunction or indeed the compliance order that's sought in relation to data protection claim. It becomes apparent that such a claim is being made. There needs to be an amendment to the claim form, and at that point you pay the additional fee. So there's no route out to paying applicable fees, it seems, certainly in my submission.
Unless you don't apply to amend your claim form.
Well, and then in which case the other party may say, well, that therefore is not a claim for an injunction.
There used to be a rule, I think, that said you couldn't recover a remedy that wasn't claimed in the claim form, so that putting it in the particulars of claim when it wasn't in the claim form didn't work. That might make sense, but I'm not sure there is still such a rule.
Well, I'm not aware, certainly in terms of, obviously I've looked at the matter and obviously particularly looked at the commentary in the White Book to 16.2 brackets 5, which talks about the idea that the court still has the ability to provide a remedy even if it's not within the claim form. And one would have thought there'd be some continued reference at that point if that was an argument that was available. But certainly in my submission, a party facing such an approach by another party seeking a remedy which it's known about but hadn't paid a fee for and would be contending to the court that such an approach was abusive, and at the very least that the appropriate fee should be paid in order for them to pursue that particular.
Yes, I mean, even if you got to trial, the court could still say, well, you've got to amend your claim form and pay the fee.
I mean,
that's the remedy you want, if that was a fair thing to do.
Yeah, absolutely. I mean, one has seen that, can't remember the case offhand, but there's a few defamation cases where that has happened.
Well, there have been cases where they've amended the value of the claim.
Yeah, well, that's it. Yeah, so in that context as well. Yeah, so that the fee that was paid originally was too low. The court concluded.
Less than the jury awarded, I think, was one of the cases.
Yeah.
Yes.
So do you say the fee is only payable in those circumstances if and when the claim form is amended to include the claim for injunction that appears in the particulars of claim later on?
Well, that's what it appears to be. That's certainly the way that the fees order seems to marry up with that.
Well, that's reading claim in a restricted sense as must be in the claim form. But if the claim overall is amended to include in the particulars of claim, then surely merely pleading it in the particulars of claim would give rise to the fee. You wouldn't have to amend the claim form.
Sorry, I misunderstood what you said. Now that's absolutely because I was thinking about this over the course of lunch. I would submit there is a distinction between, well, one is talking about in the fees order when you're talking about starting proceedings, and it's the originating document is the claim form. But once proceedings are afoot, the claim is what's in the claim form and the particulars of the claim. It's the totality of that. And therefore, if you've got a situation where the particulars of claim, certainly it would, at first blush it would appear that if you've got a situation where the particulars of claim gives rise to or raises a remedy, then you still have to pay that fee, albeit there is, of course, 16.2 where it says that you must refer to the remedy in the claim form.
You must, but if you don't, the court can still grant you the relief on a 16.5. So must does not mean must, and if you don't,
there's no sanction attached to it. No. I accept that. Yeah. But there is certainly in my submission, there is a material difference in wording, obviously, when one looks at what we just looked at, which is where the claim or counterclaim is amended, and then there's specifically different wording when we're talking about on starting proceedings, which is what I sought to place reference on in my submissions earlier. Yeah. So then I'll move on to my sort of final stage of the argument in terms of this point is addressing the first instance decisions of Batty and Dixon. And of course, first point is they're both first instance decisions which are not binding on this court. Dealing firstly with Batty, Batty appears at tab 8 of the authorities bundle, and the issue before the court in Batty was summarised first of all at paragraph 17, which is 97 of the authorities bundle. I'm not going to get into it unless the court wants me to. I'm not going to get into the detailed facts of this case, because my learned friend's already done that in his review of a helpful review of the authorities. But just insofar as this particular point is concerned, at paragraph 20, which is also page 97, Justice Warby went into some more detail about the civil proceedings fees order. And then at paragraphs 22 to 24, he considered, particularly at the bottom of 24, this is the dispute in the case there was about the value that was put on the claim. And the argument that was being made was that the fee that was paid was consistent with what had been put in the statement of value. But the conclusion of the court was that actually the statement of value was about allocation rather than specifically being a reference to the fee that has to be made. So it's a slightly different issue. Then paragraph 25, the facts of the case and in relation to the claims are set out. And on the facts, and certainly as appears in the judgment, the claim form in both the Aslam and the Rashid claim, as well as referencing the money claim, refers to further or other relief. So these cases are factually distinct from the current case because they did exactly what had been suggested in the White Book you should avoid doing to avoid having to pay an additional fee. And that gave rise to the further fee in those cases of £480. And the judgment adds that the same claim is in the particulars of claim which is issued and served concurrently. So the claim form and the particulars of claim were consistent with one another. Again, different to the current case. And then the key passage in the judgments, insofar as this part of the argument is concerned, is at paragraph 35, and that is 103 of the authorities bundle. Where it says, I'm satisfied this Britain is correct to submit that in each of the present cases there was an underpayment of fees due on issue for these reasons. First, the assessment of what was a correct fee must be based on the documents presented to the court at the time of issue, that is to say the claim form, and if it is available, particulars of claim. One must take the claim to be as stated in those documents. So obviously that's what my learned friend relies on. It is relevant, possibly relevant to note, because it's reference made to this in other authorities when citing Batty, that this, as I understand it, was an extemporary judgment, and at the end of the judgment, at 39, there is the indication, and this is paragraph 39 of the judgment, page 105 of the authorities bundle. Secondly, the matter could be addressed legally by considering the issues raised by the authorities relied on in greater depth than has been possible at this hearing. So there was an indication there that in the context of that hearing there hadn't been full argument, albeit I accept that I think that is a reference back to the more substantive issues in relation to payments of fees rather than how one calculates the fee that is payable. But in my submission, the court should not follow the indication given in this judgment that the correct fee should be determined by the claim form and the particulars of claim if available. And the reason is that the question as to what documents were relevant to calculate the court fee was on the face of the judgment, not the subject of any detailed argument. I mean, it may not have been subject of any argument at all. Not clear to me. Crucially, also in Batty, the claim form and the particulars of claim both referenced remedies other than the pure money claim. I think that's materially different to the present case, where the claim form does not reference the other remedies. Further, and bearing in mind that this is a case that was decided a few years ago, the issuing of the claim form in this case was done by the individual attending the court in person. That process does not, in my submission, entail the individual document-specific focus that one sees placed by Practice Direction 51.0, the electronic working scheme. So that provides a slightly different focus in terms of the way that it's done electronically. So for those reasons, in my submission, the court should look again at what is required in terms of calculating the fees. It's right to say, of course, that Batty was endorsed by Mr. Justice Stuart Smith in the case of Dixon. And Dixon is at tab 9 of the authorities bundle. And again, my learned friend has addressed you on that case. In that case, the court concluded where there had been an issuing of the claim, albeit potentially incorrectly, the proceedings were afoot, but the claim would be treated as being brought at the date of issue, not at the potentially earlier date when the claim form and payment had been submitted to the court. And you can see that at paragraph 46 of the case, which is at 129 of the authorities bundle. But for the purposes of this point on how one calculates the relevant court fee, the relevant paragraphs are paragraphs 53 and 55. At 53, which is at page 131 of the bundle, of the authorities bundle, it also seems right in principle that, as Warby J indicates at 35 of Batty, the appropriate fee should be determined by reference to the terms of the claim form that is issued, or if the particular claim are issued simultaneously, the claim form and the particular claim combined. So there's an endorsement there of what is said, what was said in Batty. Perhaps, and just on the point we raised earlier, it is useful to note that at the end of that paragraph, just onto the next page, 132, the judge is considering in that paragraph, well, what happens if sort of the claim develops? You might realise that it's worth more, or maybe other remedies are required, or something along those lines. And so where do you draw the line? And his point is, well, once you can articulate the claim, that's what you put in the claim form, and that's what your fee is paid in relation to. And he says, and there's a last line there, if and when the further claims or quantification can be pleaded, further fees may become properly payable. And that's along the lines of what we were talking about earlier. And then just finally on the issue of how you calculate the fees, again, he makes the point at 55 of his judgment, just again on 132. For these reasons, I hold the appropriate fee for the purpose of the principle enunciated by the Court of Appeal in Page and Hewitts is the fee required by the relevant order, which is to be determined by reference to the claim or claims articulated in the claim form, brackets, and if issued simultaneously, the particulars of claim. So, in my submission, again, it appears from the judgment that there was no specific argument as to whether the approach that had been adopted in Batty was the correct approach. On the face of the judgment, the judge just appears simply to adopt and endorse the approach in Batty. Again, as with Batty, there was no consideration of what the position would be where the remedies sought in the claim form are inconsistent with what is sought in the particulars of claim. That's because certainly my reading of the case, on the facts of the case, it wasn't suggested that the particulars of claim was sent in with the claim form at the time of issue, but I'm sure I'll be corrected on that if I'm wrong. But I think the key point is that no detailed argument on the point seems to just simply adopt what was said in Batty, and crucially the facts of the case were different, because in this case there was no suggestion that what was set out in terms of remedies in the claim form was different from what was in the particulars of the claim. So in my submission, for the same reasons as I raised in relation to Batty, the court should decline to follow the approach that's set down there and should adopt the approach that I have contended, which is that the key document in determining the appropriate fee is the claim form.
What if the particulars of claim do not claim relief that is specified in the claim form? So let's say that the claim form says further and other relief, and the particulars of claim don't.
You pay the fee, because it's the claim form that it's referenced to. It gives clarity, it provides clarity. The clarity is what's in the claim form, what's put in the claim form is what you pay the fee in relation to.
And would that be the case even if I'm pushing the case, the hypothetical case a bit further? The particulars of claim say expressly, we do not intend to pursue the claim for an injunction that is identified in the claim form.
Well, I don't know offhand whether there is provision for seeking a refund from the court. The fee that one has to pay in order for, on the analysis that one needs to pay in order for it to be brought, if that is correct, it is the fee as identified by what's on the claim form. If it then is indicated, well, actually, we didn't want to make that claim at all.
You amend and you get...
Well, amend, and then I don't know whether the court offers a refund or not. Maybe the court says, well, tough luck, you've...
But either way, whatever's in the particulars of claim, even if filed at the same time, you ignore it.
Yeah, that certainly is my submission. So, my lady, that's my second point. And obviously it would follow, if I'm correct in my second point, regardless as to whether I succeed on the third point, that the claim would have been brought in time. The third point then in a sense is alternative, on the premise that the court fee was incorrect. In my submission, the claim was still brought in time, and that in my submission is because an inadvertent failure to pay the correct court fee does not lead to a claim not being brought for the purposes of the Limitation Act 1980. So that's the full proposition. The starting point for the argument is the Court of Appeal's decision in Hayes and Butters, which my learned friend's already taken to you two. It's tab 11 of the authorities bundle. And just one can see, if we turn first of all to 164 of the authorities bundle, and this is paragraph 12 of the judgment, you can see what the court did was first of all look at the statutory framework. And just for a moment, I think the court's probably already picked this up. The statutory framework and indeed the context of this case is different to the present case, because that case was about making an amendment to a claim, and for the purposes of section 35 of the Limitation Act, what it meant to say that the amendment has been made, the claim, and so it's slightly different to the present case that we're in. So in any event, having set out the statutory framework at 12, paragraph 12 onwards, the judgment then does a detailed review of all of the cases, the relevant cases. So the two Court of Appeal authorities, Barnes and Page number 1, and then a number of the first instance authorities. Now, I should say at the outset that it is clear that the first instance authorities don't provide express support for my proposition. I have to accept that. They're all dealing with particular other issues that are before them, and they allude to some to more extent than others to issues with whether or not the payment of the correct court fee should be the correct trigger or not. But they're all dealing with particular other points, which my learned friend was quite right to say are not the same point as is being made here. At paragraph 23 of the judgment, and that is paragraph page 167 of the authorities bundle, a summary of those decisions is provided, and the key conclusion of the court, insofar as my argument for you is concerned, is what is at subparagraph 4, just at the top of page 168, where the court says the decisions of this court in Barnes and Page established that an action will be brought within the limitation period if it is delivered in due time to the court office, accompanied by a request to issue and the appropriate fee. They do not decide that an action will be brought in time if and only if it's accompanied by the appropriate fee. So then the question is, well, what is the position in relation to the fee? But actually, before I get to that point, just it's a point the court reminded my learned friend of earlier, at paragraph 42 of the judgment, and that is 172 of the authorities bundle, Lord Justice Lewison, in a very short further judgment, says, I entirely agree. The only points I wish to emphasise are these. First, in Page and Hewitt solicitors, in this court, the correctness or otherwise of the fee was not argued and not in issue, and the court gave it no detailed thought. Second, it's a mistake to read a judgment although it's a statutory text, especially on a point that was not in issue. So that is the context. Yeah. So going back then to the judgment of Lord Justice Peter Jackson, at paragraph 24, and this is page 168 of the authorities bundle, he first of all identifies the different approaches that have been taken at first instance to the non-payment or the underpayment of fees. And then he notes, as regards those decisions, and this is just between C and D, each approach involves a trade-off between the advantages of certainty and an appreciation of the justice of the individual cases. And then, whilst noting that it wasn't necessary for him to resolve the issue, he makes two further points. He says, my provisional view is that there is force in the concerns expressed in a number of the cases about the disallowing of a claim on limitation grounds merely because of an inadvertent miscalculation of court fee. And then he also says, I agree with the observations of Justice Stuart Smith in Dixon about the range of other responses available to the court to control any abuse of its processes, and then cites what was said in Dixon. If identified before issue, the court may simply refuse to issue proceedings until the proper fee is paid. Now, remembering, of course, the difference between issue and brought. So what effectively is being said here is, well, if someone is behaving badly or indeed just haven't paid the court fee, well, we have got steps available to us, albeit it's not going to prevent it being brought for limitation periods. It's just simply not going to progress until, or potentially won't progress, and we won't issue it until the proper fee is paid. So, and then there are a variety of other, if proceedings are issued, and the court could direct the payment of the missing fee either at the time of issue or later. So there are a range of remedies available there, and that's something that Lord Justice Peter Jackson had regard to. Now, adopting his analysis that the courts have sought to balance certainty with an appreciation of justice, in my submission, that balance is properly achieved, certainly in the cases where there has been non-abusive, inadvertent miscalculations to the applicable fee, by my proposed approach, namely that inadvertent failure to pay the correct fee shouldn't result in a claim not being brought for the purposes of the Limitation Act. And the reasons in my submission in support of that proposition are as follows.
Can I just understand the parameters of that proposition?
Yeah.
So inadvertent failure to pay the correct fee.
Yeah.
So you don't suggest, do you, that failure to pay the fee at all means the claim is still brought, or do you?
No, I don't. Because it's obvious. I mean, it's subject to a case where, for example, a fee isn't payable immediately. We had the example of where you have a fee waiver, for example, and you have to make an application.
Assuming the fee is due.
Yeah. So if it's obvious on the face of it, a fee is due, then on the face of it, not paying that fee is something that was in the command of the solicitor or whoever the person is that's putting the claim or seeking to have the claim issued, and it'd be very difficult to understand a situation where not paying the fee at all, not inadvertently, is a problem. Of course, there's one caveat to that. If you think you paid the fee and then for some reason, for example, the credit card doesn't work or something, and you think it has worked, then that's in my experience, that's an inadvertent.
Well, but hang on.
Oh, I see. Yeah.
That would be an inadvertent payment of the whole fee. That's why there's two different things. First of all,
I've conflated the two. Apologies. Yeah.
You build in two things: inadvertence, which we need to come back to understand what that means.
Yeah.
And secondly, it's only on your case that, as a moment ago, if the there's an error as to the amount, but there has to be some fee paid. But are you retracting from that now?
I think probably on analysis, the better because of the possibility that somebody's tried to pay the fee and something has technically gone wrong, for example, that again would lead to when one is balancing certainty with appreciation of justice, that would fall into sort of more likely fall into an unjust scenario. But so the key distinction is inadvertence as opposed to abusiveness. And I think, as the court indicated earlier, all of these things go out the window when it's indicated that a party is behaving abusively in relation to what is required by the court. So, claim form goes in, request to issue the claim, an attempt at payment, I think is probably the better way to describe that, which may fall short because inadvertent. Sorry.
Pernickety here, but there's an attempt, and therefore the fact payment wasn't made was inadvertent because there was an attempt made.
Yeah.
But what about someone who makes no attempt at all because they left it to Mr. X and Mr. X didn't receive the message, and so actually there was no attempt to make a payment at all, or it was just forgotten about, inadvertent, but no attempt was ever made?
Well, the court's got to draw a line somewhere, and there is a requirement to pay fees, and the concerns raised by the court are about inadvertent mistakes in relation to paying the correct fees. So if in circumstances where the fee is not paid and it's an inadvertent failure to pay that fee, whether in totality or to a limited degree, certainly the approach that I put forward is that shouldn't have an impact in terms of when the claim is brought.
Well, isn't it really going back to Lord Justice Tuckey and doing everything within your power, so that all that's left is something administrative? So, if you do absolutely nothing in relation to payment of a fee, that might be a problem. If you pay something and you think it's the right amount, and it then subsequently transpires that you've got your maths wrong, you're leaving it to the court to issue the fee, issue the claim form, because that's what you're expecting to happen, and instead the court comes back and says, no, you're actually £6 short.
Yeah.
That's the situation where you say, well, you read that together with the rules, and the rules say that you've got to pay the correct fee on issue, and provided that you have rectified that mistake by the time that the court issues it, you've complied with the rules, and you've done everything within your power to bring the claim within the appropriate period. Because you can't be blamed for the fact that you're £6 short, or whatever it may be. The contrary argument is you haven't done everything within your control, because if you leave your proceedings to the very last minute, you're expected to actually read the rules and get the figures right.
Yeah, well, yeah, of course. Those are the two competing arguments.
Does inadvertent in your formulation encompass negligence? That's
it must do. Yeah.
It must. So a negligent, non-intentional.
Well, non-abusive. Yeah. So,
non-abusive.
Yeah. I mean, because of course.
Would it extend as far as reckless? Because inadvertent may simply mean not intentional.
Well, it extends as far as into the limits of not being abusive. Of course, my lady pointed out with reference to Lord Justice Tuckey, the moment one adopts as holy script the formulation as much as you can be expected to do, then of course you're into behaving in a competent manner, and then of course you have to comply with every procedural requirement that's there, because one can expect that you should be reading.
Well, you see that's I'm trying to sort of rationalise that approach with the approach that you're putting to us.
Yeah.
As to where the line is to be drawn between undue harshness for somebody who really shouldn't be blamed for what's happened. And Mr. Wills says, well, if it's the court's fault, basically, the court has told you that what the fee is and they've got it wrong, or the court sits on its hands and doesn't sort out your claim for help with fees, then that's not something for which you can be blamed. And if you look at all the limitation cases in this sort of line, suggests that once it's handed over to the court and it's down to the court to get things right, then you shouldn't be blamed for it. That tends to suggest to me that negligent failures, oversights, etc., fall on the wrong side of the line so far as you're concerned, because until that claim form leaves you with the fee, which is the correct fee, there's nothing you can blame the court for.
No, I accept entirely that on that analysis, that it's the transfer of risk that, and indeed I think in the judgment of Batting, that's what
yes.
what Lord Justice Warby said, which
yes.
was, well, there is, and indeed that was a question of fact which had to potentially be determined. Did the court make a mistake? Completely accept that if that's the approach the court takes, then on this case one cannot succeed. In my submission, the proposed approach, and indeed I think it was, I can't remember, it was the first or the second of the alternatives that Milady, you raised earlier, which was that you've got to pay the correct fee on issue. So what that does allow is a scenario that the claim is brought, but it's not, and then the court can potentially then come back to the individual and say, well, hang on, you haven't paid enough. And that is where, in my submission, the difficulty and potentially the injustice arises, because at that point there is an uncertainty in terms of the amount of time it might take a court to consider a claim and potentially form a view that the fee paid and offered was insufficient. The uncertainty of the time it may take to do that administratively leads to inconsistency, and as a result, injustice. That's because it's simply a matter of luck for the claimant if the court comes back to them quickly and says, before limitation expires, point out the mistake. And in the present case, there was a delay of a few days, which meant that all aspects of the defamation and the malicious falsehood claims were rendered out of time. But had the claimant been lucky, and had the court acted a few days more quickly, the situation could have been remedied, and at least one aspect of the defamation, malicious falsehood element of these claims would have been in time, notwithstanding the fact that the default was the same. So that in my submission is where the injustice lies, which is you're just really reliant here in terms of whether you're going to be saved or not by how administratively quickly the court comes back to you to say, hang on, this has gone wrong, you need to do X. And at that point in time, you're able to remedy the situation.
And I'm still troubled by how one fits help with fees into all of this, because it's necessarily part and parcel of the scheme. Although the rules that you've read us out suggest that you have to get all of that sorted out before you launch your papers electronically anyway. Certainly in practical terms, that's not what happened in Bali. And what happened there was that the application for help with fees was issued in time, but it took the court a very long time to work out how much the part payment should be. So on any view, the claimant had not paid her share of the fee within the limitation period. And yet it was accepted. There wasn't an issue about it. It was accepted that the claim was brought in time.
Well, one can only, my understanding of that, and I think it was a point my own friend made to the court during the course of his submissions, is that the relevant step from the purpose of doing all that you can at that
is the
point
issue of the
So I can see how there's sort of how that works in a slightly different way.
Well, so can I, but it rather cuts across accompanied by the appropriate fee.
Yeah, indeed, yeah. So there's another. So that's one of the sort of injustices in my submission, which this different approach would solve, and it's the injustice of just the luck in terms of how quickly the court's going to come back to you to say you've got a problem. The other potential injustice or inconsistency is raised by what is said in Dixon by Mr. Justice Stuart Smith. And in that case, if the court accepts that analysis, the court can erroneously issue a claim in circumstances where on analysis the fee was inadequate. In those circumstances, despite the fact that the default would be the same, there would be an inconsistency because on his analysis, the claimant would still have their claim brought for the purposes of the Limitation Act, notwithstanding the fact that they actually hadn't paid the right fee. They've just got lucky.
Yes, and I think that the rationale is that you can't have an issue unless the claim's been brought.
Yeah.
And so if the court has actually treated the claim as having been brought, you either look at it in terms of some kind of estoppel, or you say, no, it's been brought the claim has been brought for limitation purposes in that scenario, notwithstanding that a fee's not been paid.
Yeah.
And that is a point in your favour.
Yeah, that's it. It gives rise to inconsistency and justice, and that, in my submission, is supportive of taking a different approach to the way. It is relevant to note in my submission on the point of injustice, the observations of Mr. Justice Stewart-Smith in Dixon at paragraph 70 of his judgment, which is 1370. 137 of the authorities bundle. And it's just in the middle of that paragraph, where it says, to my mind, the undesirability of the principle for which the defendants contend is brought into sharp focus when it is remembered that the payment of fees is a matter for the benefit of the court and is very largely irrelevant to the opposing parties. When asked what actual prejudice their clients have suffered as a result of the asserted underpayment of issue fees, counsel for RHB and the CRA were unable to identify any substantial prejudice at all. The best that could be suggested is underpayment of issue fees left the claimants with more money to fight the defendants. So, in that context, given that the payment of fees is for the benefit of the court, the range of measures that was set out paragraph 24 in the judgment of Lord Justice Peter Jackson, citing what was said in Dixon, is sufficient to safeguard the integrity of the court. You prevent someone continuing with their claim until they've paid up. Now, I would accept, and it's the argument that's often made by, not specifically in this context, but generally when one is seeking to avoid limitation, seeking relief in relation to something in relation to limitation, that it would be said that this approach would deny a limitation defence to the putative defendant. But in my submission, that's really a circular argument, given that what we're considering is where one draws the line in terms of what has to be done for a claim to be brought under the Limitation Act. Limitation defences would still be available to defendants. The line is simply being drawn in a different place. Really, the important point is that the current approach allows the defendant a windfall limitation defence on account of a potentially very minor inadvertence on behalf of the claimant in relation to the payment of the fees. So, in summary on this point, I can't point you to first instance decisions, albeit there's been a lot of consideration of this issue at first instance, which supports this proposition. But as has been observed by this court, there needs to be some clarity about what the proper approach is as regards fees. And in my submission, in terms of the appropriate way to balance certainty and justice, that is determined by the approach that I propose, rather than suggesting that correct payment of fees per se, along with the issuing of the claim form, is what is required in order for a claim to be brought, as opposed to being issued, for the Limitation Act. So, for those reasons in my submission, that is the approach the court should take. And of course, that's an alternative to my primary submission, which is that the correct fee was paid by reference to the claim form. Melanie, that's all I have to say in terms of my submissions.
Can I just
Yeah.
be absolutely clear about that, as we don't have any respondent's notice or skeleton on any of this. So let me be clear about this. Your submission, I think, is that payment is a precondition to the issue of the claim.
Yeah.
But isn't a precondition to it being brought.
Yeah, correct payment. Yeah, that's correct.
No, well, correct payment or any payment.
Well, yes, but I suppose, but any payment stroke correct payment. Yeah, the payment issue is separate. That's applicable to issue, but not necessarily applicable to the claim being brought.
And that's how you put it.
But of course, the court. I mean, I say that, and my submissions are made in support of moving the line in terms of where the court should place it for the purpose of determining when a claim is brought for the purpose of limitation. And of course, your lordships, your lady, may conclude the line is drawn in a slightly different place, but not fully where has been suggested by an learned friend, namely that the correct fee needs to be paid, and that's the end of the matter. So I said, those are my submissions. I am conscious, obviously, that there is the other appeal. I don't know if you just want me to address you on that briefly.
That might be helpful. Yeah, that might be helpful.
Yeah, I can address you very briefly. It is, on analysis, completely correct, it seems, that the first defendant was not properly notified of the hearing before Deputy High Court Judge Alegre.
Yeah.
And that is because there was an acknowledgement of service that had been provided, and it provided a postal address, but that all of the notifications provided by those who instruct me to the first defendant were sent to an email address, which doesn't appear to have been acknowledged on the acknowledgement of service, and appears to come simply from the work of a private investigator. So it cannot be said in my submission properly that the first defendant was on notice of that hearing. But of course, the next question is there any prejudice? In my submission, there is no prejudice because the second and third defendants, legally represented, have addressed the issue that was before the Deputy High Court Judge, albeit they lost at first instance. They're here before the Court of Appeal and the matter is being fully argued here. So the first defendant hasn't suffered any prejudice, but I have to accept that they were not properly notified of the hearing.
Well, that's very fair. Thank you.
Right.
Mr. Wells.
Just bear with me one moment, please. As my Lord Justice Zacaroli observed, that of course none of this is featured in a respondent's notice or in a skeleton argument, so we have of course been hearing this for the first time, and I shall do my best to respond on these points.
Is that right? You didn't know what was coming? Because we didn't. We just wondered whether someone had at least given you a tip.
Sorry, no, we did. We had no sense as to what was coming. But I think in fairness to Mr. Lima, he was also instructed quite recently.
No, I'm not implying any criticism of Mr. Lima.
No.
Just trying to explore what the factual situation is.
I'm grateful for your checking.
Do you feel you want more time? I mean, I certainly, speaking for myself, wouldn't be averse to giving you the opportunity to respond in writing if you feel that you would be more comfortable in doing that, given the circumstances.
May I turn my back and take instructions on that?
Well, that's the fair thing, isn't it?
Because it's an important point.
Yeah.
I think we really want. It's an important point for them, but it's an important
point generally. I think they ought to plead it.
That should be done formally anyway.
Yes, yeah. But it's more unsatisfactory to try and adjourn it over for another oral hearing.
Yeah, I think it seems like
Yeah.
I'm grateful. I'm going to try and address it as best I can now. One point I wanted to flag is that if the court would appreciate written submissions from the two of us on any particular points which may arise as you're thinking about your decision, speaking for myself.
No, absolutely, completely understand that.
We'd be very happy to assist.
I think you've both been extremely helpful. No criticism, of course, intended of either of you. Certainly not Mr. Limar. I think that the position should be formally recorded in a respondent's notice so that the issues are identified that the respondent actually wants to take, and you've heard them articulated today, so that shouldn't be too difficult to be done. And then I think you should both have an opportunity to put in something in writing. But if you want to make some brief oral submissions to us today, or longer oral submissions to us today, of course we're not going to stop you.
I mean, I can be very brief now, but I think we'd welcome the opportunity to do that. Of course, if they're putting in a respondent's notice,
Yes.
then to have an opportunity.
And we certainly give you plenty of time. We know that that Christmas is coming up, so I don't know whether 16th of January would be a good time.
I'm very grateful. I thought for one moment we were going to get a deadline next week, which would have
No.
I'm very grateful, yeah.
Sorry, just to flag a problem with my availability, I'm actually not back until the 15th. So if we have a little bit longer, we'd be very grateful.
Another week after that?
Where does that take us to? I'm sorry, I need my diary.
23rd. If there's a problem, let us know, because you're the one who's on the back foot on this. And so if you want more time, I think we're likely to be sympathetic to it.
I'm grateful. I'll make a few brief points now with that all in mind. In relation to the jurisdiction point, we would of course accept that a court has jurisdiction to declare that a claim was or wasn't brought in a particular time, or that any other state of affairs did or didn't exist. That wasn't, of course, the jurisdiction that Deputy Judge Alegre was actually invited to exercise. And you have my submissions as to why, in any event, her conclusion in respect of that was flawed as a matter of both law and fact. Mr. Lima made a number of points about it being down to luck in terms of how long it takes the court to get back to a claimant in circumstances in which they proffer the wrong fee. With respect, we'd say it's not quite right, because perhaps for want of a better way of putting it, claimants doubtless make their own luck in this kind of situation, because first of all, it's within their gift to ensure that they have understood basic rules around the calculation of fees. And secondly, it's within their gift to ensure that they don't leave things to the 11th hour. Mr. Lima talked a lot about the concerns around prejudice or injustice that could arise, but his submissions ignored entirely the possibility that under the Limitation Act, the court has a broad discretionary power to extend or to disapply limitation periods where appropriate.
Well, it does in this case. It doesn't generally. If it were a personal injury case, it would have it. If it's a defamation case, it has it. It certainly doesn't have it in a planning case, and it wouldn't have it if it was a normal 6-year period. So that was why I said earlier on to you, if there's got to be a bright line drawn, you can't really rely upon the fallback position, which is that in some cases you've got an ability to use a particular statutory provision to get out.
I would accept that point, my lady, and I must confess that in preparing for this, I've not looked at the scope of that discretionary power in relation to other practice areas that are not.
There are a number of practice areas where it's best known is personal injury. And for defamation, there's that slip as well. But there are certain areas where it's even tougher, and planning statutory appeal is one of them, and there's absolutely no discretion in the court. So,
in relation to Mr. Lima's broad, and we would say bold, submission that payment is only a precondition of issue and not of proceedings being brought, we say that's wrong for the reasons I addressed earlier.
Yeah.
It would also, of course, require the court to depart from a number of decisions of the High Court which we would say are clear and compellingly reasoned. And as I took the court to that earlier on. Now, in respect of Mr. Lima's...
Sorry. And this may be something you want to think about in your submissions, but I'm interested to know your thoughts on the extent to which that proposition would cut across the conclusion of Lord Justice Tuckey, which has been followed since, that the rationale of the rule is that the claimant should do all that's within their power to do. Would his proposition that paying the fee is a precondition to issue but not bringing the claim cut across that?
If I may, I think we'd take the opportunity to respond on that in writing, my lord. So it seems to be common ground that if, once proceedings are issued, you increase the value of your claim or you add claims for other remedies, you have to pay a higher fee. That's dealt with at paragraph 10 of Hayes and Buck. And that would, of course, apply if you filed and served particulars of claim further down the road. In our submission, it would be artificial and we would submit unprincipled for the court to simply disregard and close its eyes to documents that are presented to it at the time of issue, in circumstances in which it can already be seen, for example, from particulars of claim, that fees additional to those that would be due if one focuses on the claim form alone fall due to be paid. We say that simply cannot be right. And that's essentially for the reasons given by His Lordship and Mr. Justice Stuart Smith in Dixon and Batty respectively.
On the other hand, it might be said that it's somewhat artificial to treat a claim as being brought or not brought for limitation purposes under Section 1 of the Limitation Act, depending on whether you serve your particulars of claim with your claim form or you wait for 14 days.
I suppose, my lady, in that scenario, the court simply doesn't have the benefit of whatever's going to be said in the claim form, and it would be necessary in that situation if a claimant were to include additional remedies or a greater claim for damages, it would be necessary for them to then pay the increased issue fee straight away upon filing the particulars.
See, what you've got is two identical scenarios. The claimant always intends to seek an injunction, but for whatever reason doesn't include the claim for relief for an injunction in the claim form. Scenario 1 puts it in the particulars of claim, and the particulars of claim accompany the claim form. You say should have paid the full fee and therefore time barred because they haven't brought the claim. But exactly the same state of mind, exactly the same intention, everything else happens, but doesn't serve the particulars of claim for another 2 weeks. He's in time, having brought the claim for limitation purposes, but he's got to pay the extra fee at a later stage. Just seems a bit odd. Maybe that's something you want to think about, because it just strikes me as being a bit strange that you end up with a different scenario depending on when you choose to serve your particulars of claim.
But my lady, what I would say in response to that at this point is that all the court can do is look at the information that is presented to it upon somebody filing.
When you've got the two pieces of information together, it's self-evident that somebody wishes to bring a claim which encompasses an injunctive claim, and the fact that they've left it off the face of the claim form isn't an excuse to enable them to pay a lower fee.
That's correct, Mady, and we would also say that it cannot be right that the court would be required to ignore that, to simply disregard the fact that you've got particulars of claim that, for example, claim that there's a much greater claim for damages than is stated on the claim form, all of that being done at the same time. And the other point that we would make in this regard is that, of course, particulars of claim can be served as a separate document, but they can also be included, and indeed, in many claims, for example, at county court level, are included in the claim form, if matters are simple and brief. Yeah. Now, it's not clear what Mr. Lima was saying about that, but I understood his submission to be that in that situation, if you included the particulars of claim in the claim form, then you would have to consider whatever was stated in those brief particulars in terms of value or remedy.
So it turns on the nature, whether the nature of the claim requires you to put something down that exceeds the space on the form, which would be arbitrary.
I would respectfully agree.
Unless it's an expandable form, I don't know.
I'm not sure about the electronic ones.
No.
Just one moment, my lady. I'm seeing if there's anything else I want to. No, I don't propose saying anything else at this point, but in writing there may be a few further points that I'd like to make, and we'll do our best to address the points that the court's raised as well.
Well, thank you very much indeed. Thank you both of you for your helpful submissions. Obviously, we'll adjourn the matter and await your written submissions. Mr. Lima, is it going to be all right if we direct that yours come in by the 16th, and then we'll give Mr. Wills till the 23rd? And if you need more time, just let us know.
Great.
If that's too tight a timetable.
Did you want us also to formally send in effectively an amended respondent's notice?
Yes, please.
Yeah.
I think we'd like to see how it's articulated and obviously serve it on the other side. Same deadline, if that's all right. Yeah. And then we will obviously consider what you have to say. And in due course, we will hand down our judgment in the normal way. It doesn't need me to tell you that the normal rules apply, so handed down in draft, embargoed. We take the embargo very seriously. And you'll let my clerk know the addresses and names of people to whom it should be circulated, please. Thank you very much. Have a nice Christmas. Thank you.
All right, able.